Try it again. Hello, everyone. This is Tessa Jacob with Husch Blackwell. I am the leader of Husch Blackwell's eDiscovery Solutions team. I spearhead the firm's efforts to provide consistent, defensible, and repeatable eDiscovery solutions for our clients. I also regularly work with on employment matters with our L&E attorneys, and that's what I'm here for today. I'm here with Tim Hilton from our L&E group. Tim focuses his practice on defending employers against employee lawsuits and counseling employers on best practices to avoid potential liability. Additionally, he has a focus on employment-based immigration compliance, specifically related to Form I-1 and E-Verify. So today we're excited to have a presentation on current trends and best practices in eDiscovery as it relates to employment litigation, from preservation and legal holds to social media as sources of evidence. Before we begin, I'm going to turn it over to Ashley for some housekeeping items.
At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate audience participation and encourage you to submit questions. There is also an icon to assist with your viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck and additional materials are available in the resource icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You'll need your bar numbers to submit. Please make sure to do this before the webcast concludes. This program has also been approved from HR Certification Institute and Society for Human Resource Management Recertification Credit. Recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with certificate of attendance and a copy of today's slide deck. Thank you.
Okay, Tim, let's start with our kind of agenda for today. We're going to cover basics of legal hold, what it needs to look like. Also, we're going to start with triggers. And we'll also address a little bit about sanctions and today's new rules. And we're going to end our seminar today talking about investigations and specifically what you need to be aware of as you're doing investigations and looking at people's computers, smartphones, and social media. So Tim's going to get us started today with some basics about legal hold.
Thank you, Tessa. Yeah, the first kind of section of our presentation we have down as legal hold triggers, and we're going to cover the who, what, when, and why, and then we're also going to cover kind of the where and the how, which are sort of practical tips on what needs to be preserved and how you go about doing that. So the first point that we have to cover is, why do we have a hold obligation? So employment law has been a unique area of litigation, but it has been key to the development of legal hold case law. And this, the most important case over the last 20 years or so is the Zuba Lake case, which Tessa and I talk about a lot. And there's a series of opinions that were issued by a judge in New York federal court that comes from a claim of gender discrimination and retaliation based on failure to promote that was filed by a plaintiff named Laura Zuba Lake against UBS Financial. And it's interesting because, that probably sounds somewhat similar to employment cases that you've handled. It certainly sounds similar to employment cases that I've handled. And the judge, Shira Scheindlin, has spoke about this case many times over the last 15 years or so, and makes clear that this is not some shocking, unbelievable case of horrendous discrimination. It's very similar to the garden variety employment claims that we get, that we defend on a regular basis. and it's unique only in the sense that the parties used it as a way to develop important legal hold and eDiscovery case law. And the way it first came about is after initial discovery, the company UBS produced about 450 pages of documents, which included about 100 pages of emails. Now, 15 years later, that sounds like not very much, especially for a very large entity such as UBS. And the plaintiff recognized that and said, well, I've printed out more pages of emails myself than the company produced to us in discovery. So they asked for more information about the backup processes and things like that. And UBS's attorneys kind of balked at that and asked to shift some of the costs of that to the plaintiff. And Judge Scheinlein, in her first opinion, basically said you can't do that. This is pretty basic discovery. Ultimately, it was discovered that some of the backup tapes had been lost, and Zuba Lake sought sanctions against UBS, which were initially denied as basically due to lack of prejudice, that she couldn't show that the importance of anything that was on those backup tapes. And finally, sanctions were issued in a final opinion against UBS, and Judge Scheinlein outlined the company's duty to take, then company's counsel's duty to take affirmative steps to preserve relevant data upon notice of a legal claim. Now, employment practice is different than other types of practices in that you don't simply get served with a lawsuit and that's the first notice of a claim. The administrative process, meaning the EEOC or the state level charge of discrimination, is pushing the hold obligation back further and further from when there's ever a case on file or when discovery begins. And I can tell you, as of right now, cases are often pending in front of the EEOC or a state-level agency for years. 6 months to a year or even over a year is not unusual. Some of the state agencies are not taking any action to dismiss it unless it's requested by the charging party. So that has the practical effect of pushing the company's obligation to issue a legal hold back further and further from the date that they might ever have to actually produce the documents, and obviously before the documents might ever be offered in court. Now, as we all know, employment cases are not any different than your standard civil case in the sense that ultimately it's very unlikely that a case is ultimately going to go to trial. It's hard to pinpoint, but most lawyers will tell you that somewhere upwards of 95 to 99% of civil cases will ultimately get resolved by court dismissal or by voluntary settlement before they ever make it to trial. But to the extent that you have a risk of losing relevant data, every day before resolution is presenting more and more risk. And I suspect the lawyers in the Zuba Lake case for UBS saw this as, pretty much your standard case, not anything to be particularly concerned about any more than all the other cases they were probably handling. And you never know if you're going to end up with a plaintiff or an attorney on the other side who wishes to take the case to trial. And ultimately, if you've got data that has been lost or has arguably been lost, that makes each day before the case is ultimately dismissed one way or another a risk. And a risk of what? Ultimately, the ultimate resolution of potential loss of data could be court-issued sanctions. And we're going to talk about sanctions a little bit later on, and we're also going to talk about some of the practical implications of lost data. So that's a little bit the basics on the why before we get into sanctions later on in the presentation. So when does the hold obligation arise? And I can tell you, unfortunately, lawyers like to give the answer of it depends, and this is really kind of the ultimate it depends question. There really is no universal answer for when a hold obligation arises because every case is unique and it'll depend on when the company is put on notice. I can tell you even legally, this is going to be a case-by-case and a state-by-state / in federal court, a circuit by circuit determination of what standard a court is looking at a particular time. And you may not know what court is going to hear the case when you initially get notice of the claim. A basic safe standard is that when you as the party are reasonably anticipating litigation, that you're under an obligation to preserve relevant documents. Unfortunately, when that occurs, when you are reasonably anticipating litigation, is not always perfectly clear. Now, there is a movement in the law. There's an outside group called the Sedona Conference that looks at a lot of eDiscovery issues, and there may be in the future a move towards looking at it more as a credible probability versus whether the party is actually anticipating litigation. But there are some basic, unquestionable triggers of a legal hold obligation. I mentioned a charge of discrimination is how most of the cases that I handle are initiated. And if you leave here not learning anything else, it should be that if you are served with a charge of discrimination, it's not notice of potential legal action. It is a legal action in and of itself. A legal claim is being raised against you. It's not really a question of reasonably anticipating litigation. You are in litigation already when you are put on notice that a charge of discrimination has been filed against you. Unfortunately, it's legal action where you might not have to do discovery for, as I said, 18 months or 2 years from when you first received the charge. But you are under an obligation to preserve relevant data when you receive notice of a charge of discrimination. Obviously, when there's a filing of a lawsuit, there may be cases in which, for whatever reason, you don't ever receive a charge. Obviously, breach of contract or some other sort of claim is one where you wouldn't ever have been served with a charge of discrimination.
Tim, what I do want to mention with the lawsuit, it's not service of a lawsuit; it's notice of a lawsuit. So when you get those courtesy lawsuits with the courtesy copies, you should be instituting a legal hold at that point.
Yeah, that's true. Service of a lawsuit is going to be a formal process that puts you under an obligation to respond. But if you learn through the grapevine or through an informal notice from the other attorney that, hey, I've filed this case against you, and management level people at your company are learning of this, then yes, you're under a legal hold obligation. And the same is true of a demand letter that threatens litigation. We're going to talk about some of a little bit more gray areas when you receive a letter from counsel or a letter from a potential party. But a demand letter that says, I have a claim against you that I'm going to file, and here's what I'd like to resolve it, that's no different than a charge of discrimination. That's no different than a lawsuit. And I can tell you that some plaintiffs' attorneys, some employment plaintiffs' attorneys are before they really even decide what their claim is going to be, I've gotten sort of vague, what I would call a preservation letter that says, I'm going to file a claim of retaliation against you, and now you're on notice of your duty to preserve documents. And other than saying retaliation, it didn't really say under what basis or anything like that, but we did institute a legal hold at that point, even though it wasn't stated what the claim was going to be, and I suspect that the plaintiff's attorney didn't even know at that point what their claim was going to be. And closer cases, in terms of when you're under an obligation, you should consider, obviously, most of your litigation may be as a defendant, but if you're ever pursuing litigation as a plaintiff, you should always be aware of that. When you're making the decision to pursue a claim as a plaintiff, when that decision is reached, whenever that is, you are under an obligation to preserve documents that may be relevant to the claim at that point. And, the final, where we spend a lot of our time advising clients, are on the gray areas when a lawyer or a party has made or a potential party, I should say, has made some sort of a vague statement, or you've heard something through the grapevine that an employee is talking about making a claim, or you've received a letter from an attorney that's not as clear. So we have a hypothetical here that Tessa and I are going to discuss. So you've got a problem employee, And if you work in HR or you handle employment claims, you can probably guess what a problem employee is like. The person who's maybe on discipline, is in job jeopardy and at risk of termination. Maybe they've made some complaints about their supervisor to some extent. But suppose you, as the director of HR, receive a letter from the employee's attorney stating that the person wishes to negotiate a severance. There's no explicit threat of a lawsuit. So the question I would have for Tessa is, should an employer reasonably anticipate litigation on that basis?
Purely a letter that comes and says that, I represent Sally Smith and she was terminated, or we understand you're about to terminate her and we want to negotiate a severance package. If there is no threat, a credible threat of litigation, I would say no, you don't. There is no trigger right there. There are older cases, but there are some cases that discuss sending a letter merely saying that you want to work something out, not saying that you are anticipating litigation, isn't sufficient enough to give a party notice. So I would say in this first circumstances, no, not yet.
And I think the same question would be if the standard is ever altered in the future, is there a credible probability of litigation simply by receiving this letter? I think the answer to that is no. And of course, this is a hypothetical that we're creating in which the attorney is very clear that there's no threat of a lawsuit. They might even explicitly say that we're not interested in pursuing litigation at this time. Obviously, that's the best case scenario. So, Tessa, what do you think if, say that this is an employee who has had a previous claim against the company, and even from this attorney, would that alter your thoughts about whether there's a hold obligation?
I think it gets to a little bit more of a gray area here. I would say initially, no. I mean, you shouldn't have to think about previous claims when you're deciding for the present letter that came through, do you have to issue a legal hold. However, some states are a little bit looser on that, and you're talking about the credible probability. And then the other thing you have to think about is that even if you don't have an obligation to preserve, I mean, maybe you want to think about it. It's a risk that maybe we need to preserve, the company needs to preserve documents that could help.
And what about if the employer seeks legal advice from outside counsel or inside counsel about how to respond to this letter? Does that, in your mind, change? Talk a little bit about to what extent that can change the trigger.
So if you're reaching out to somebody in your general counsel's office, or you're reaching out to outside counsel, Tim wants to know, does that change the situation? I would say seeking legal advice on its own doesn't raise a trigger. However, if you are then hiring outside counsel, or general counsel continues with an investigation to determine if there is a credible claim, then the situation kind of gets into gray area. The thing that you have to really think about is if you have outside counsel do an investigation, or in-house counsel do an investigation, and you get to the point where you're creating documentation, you have to think about this. If you are in a situation where down the road you want to claim a privilege, and specifically a work product privilege for those documentation, then I would say that you are getting very close, if not triggering a legal hold obligation. Because the issue is that the elements for whether or not something is protected by the work product privilege includes the element that you have anticipated litigation, which is the standard for a legal hold trigger. So there are cases out there where you see the situation arising where an HR director may have made handwritten notes, and that could have been turned into a typewritten page, and the handwritten notes are thrown away, and those typewritten notes are later become an issue in discovery, and the company wants to say that those typewritten notes are now, they were created in anticipation of litigation, and we want to claim work product. And then from that very date, plaintiff's attorneys are going to look to see, well, what have you preserved? So all of a sudden, if you have thrown away those hard-written notes, you have a spoliation issue. So you have to be really careful when you are doing investigations, when you're hiring outside counsel, and specifically what for. But this also brings up the issue of, let's assume for a matter of fact that the letter itself did actually raise the issue of litigation. One thing I did want to bring up is there's a larger question is it's anyone's knowledge enough, anyone in the organization, which is kind of a little different than what we have on the screen, but I want to talk about it. And this is an area that becomes difficult. It's a gray area. There's a lot of different law on there, but one thing that I do want to say is you don't have to send that notice that threatens litigation to legal counsel.
Yeah.
In fact, if it goes to HR, I would say that threatens litigation, that is sufficient. In fact, if it goes to a manager, a higher level, what the court's going to look at is that as the person that received notice of the litigation, anticipated litigation, whether it's written or whether it's oral, are they high enough in the organization to provide notice and knowledge to the corporation? The Zuba Lake case that we started off with is interesting. The court said in that case, Laura Zuba Lake notified her employers or her senior level managers. A lot of people in the organization knew that she was threatening to sue. The court did say that the trigger in that case started at least as soon as the charge, but probably sooner because there were people high enough in the organization to have that. So think about that as an issue.
Yeah, and we just had a few other little alterations on this. Tessa kind of covered if it's addressed to the legal department, I think that at least raises a little bit more of a gray area in terms of why are you sending this to counsel for the company if you're not planning to sue them. And then if, whether it's a contract employee or a contractor, independent contractor, not even really an employee, or if you alter the demographics of the employee to make the risk of a discrimination claim somehow more likely, ultimately, as we talked about seeking legal advice, you can look at a situation and say, yes, in the abstract, this is a situation in which there is a risk of litigation, but still you have to reasonably anticipate litigation. People that work in HR and have handled a lot of employment claims can probably tell from an employee after a while of working with them that this is somebody who might raise a claim against the company. But unless and until you are put under some reasonable anticipation of litigation, it doesn't matter if this is somebody who is a white male who ultimately wouldn't have a very good claim if it were ever filed, or if it was somebody in several different protected statuses. You still have to reasonably anticipate litigation. And go ahead.
Yeah, we just got a question
that we want to cover, and the question is, outside of storage issues, what is the problem with putting a legal hold in place in a gray area?
Yeah, there isn't a problem, but one thing that I do run into is that there are a lot of clients out there that seem to be very, very risk averse, and so you do get into a situation you're saving a lot of stuff. But one thing I would caution is if you are in that position where you are triggering a legal hold in that gray area, you want to be consistent. What you don't want to get in the situation is that it's a gray area, so I'm going to do a light legal hold, which is never a good idea. And you want to be careful that you're not just preserving stuff that would help the company in its defense. If you're doing a legal hold, it's okay if you're doing it in a gray area, but it can't be a light legal hold on one thing and a heavy legal hold on the other. The courts are going to look to make sure you're consistently doing stuff, that you have a policy and a practice that you are preserving the same items, that you're not picking and choosing what would help the company. That's the only caution that I would really say. Besides it's going to increase your costs and you're going to have issues down the road. It's okay to do it, but just make sure that it's not one-sided.
Yeah, the practical implications are big in terms of storage and in terms of just institutional efforts in managing a lot of legal holds. One thing I would say, just to follow up on what Tessa said, the situation I mentioned earlier where someone sends sort of a vague letter to say, we're going to file a claim against you, that's not a situation where you do a light legal hold, but the vagueness of what you're learning will at some times impact what you're preserving, because if you don't know what the claim is going to be about, you don't necessarily know what to preserve. So I'll often send a letter back to the attorney in a situation like that saying, you're not providing us any information here, so we're taking reasonable steps to preserve relevant documents, but we're limited by not knowing what the claim is going to be. And just to follow up briefly with another hypothetical, suppose you have an employee who's about to be terminated, who in a meeting with their HR folks or with their manager about being terminated, being severed, they say, well, you've got all these OSHA issues, and you could substitute in here an internal complaint of discrimination or an internal complaint of retaliation or harassment. In this situation, the person could make a claim to the Department of Labor. They could make some sort of wrongful discharge in violation of public policy claim. And again, reasonableness is the key here. And I get this question a lot in terms of so-and-so says they're being discriminated against. Does that trigger a legal hold? And just standing alone, the answer to that is no, because that's not a legal claim. It's an issue that puts HR obligations on us to investigate and to take remedial action if we validate the complaint. But the simple fact that somebody is raising an issue that might someday become a legal claim does not.
Okay. Yeah, let's get to the next slide.
Yeah. And yeah, we've covered a lot of these hypos already. And so Tessa's going to talk a little bit about
written legal
yeah.
hold. So generally our recommendation is that you do issue a written legal hold. The recommendation is that it should come from in-house counsel or outside counsel, so that we like to be able to at least attempt to protect these documents as privileged. It is best to issue a separate legal hold to IT and to custodians. And custodians would be the relevant key witnesses, but it could also include supervisors and managers, and it could include source custodians like HR and records and maybe offside records, people that have information that is relevant to the matter but may not be witnesses in the case should receive a notice. Less obvious people is, considering whether or not there are to issue legal holds to lower level people that may only be tangentially involved in it. Most of the time I am trying to keep it narrow, that it's really people that would have documents. And we do have some clients that really specifically to control kind of the rumor mill issue that they are very narrow. But either way, one thing that I would caution is you always want to make sure that IT gets a hold notice, and you always want to make sure custodians get a hold notice. And it's really not a good idea to forego either of them. One thing is if you ask IT just to preserve everything without talking to custodians, they may not know where they're stashing their items. At the same time, if you only ask custodians to do something and you send that same notice to IT or don't send them a notice, they won't know what to do. So it's important that you get both those notices out. You've got to consider where you might even have instances where somebody like your outside counsel that handled previous matters could have data that is no longer available to the company that has information and that's important to this current matter. You may need to send them a notice as well. And we'll talk about third-party notices again on a later slide.
So I'm going to talk a little bit about the key components of what I would call a custodian hold, and that would be a hold that is sent to key witnesses. You need to make clear what the relevant time frame is. Again, in an employment claim, that may not always be clear. I've sent out legal holds that state that there's a relevant time frame going back to the person's employment date with the company, with the understanding that the likelihood that, if they've been there a long time, documents aren't going to be available, but in the event that someone has been keeping a what I would call a desk file or a shadow file with documents that go back to, 20 years ago, paper documents that go back that far, you don't ever want to be in a situation in which somebody, and I've had this, I can tell you I've had this, the client rep sitting at the plaintiff's deposition thumbing through a file, and I asked him, well, what is that? And he said, well, this is my file that I kept on the person. I said, okay, well, we needed that. We asked for that a long time ago. So you don't ever want to be in a situation where that person is at their deposition and they say, oh, no, I have a file on this, but I didn't understand that it covered that far. I didn't understand what was covered. And that's the same thing, relevant topics and subjects. Again, you're going to have to look at the claim that the person is raising, but obviously, their personnel file, correspondence about any discipline or performance counseling that they've received, any correspondence about the reasons for termination are certainly going to be relevant. And then it's often governed by specifically what they're saying, and you want to consider people that are similarly situated if they're making a sort of claim of, well, people who are not in my protected class that hold my job were treated under different standards.
Yeah, and the only other thing I would add is I generally counsel people to be broad but be specific. So we've seen cases where inside the charge itself, they'll mention things, not just this particular email that was sent, but I know that the general counsel always used some sort of notebook to write in that, or that I've seen there was a picture that was on my supervisor's desk. If something is specifically mentioned in the charge for the complaint, you really want to make sure that that item is preserved.
Yeah. And the relevant sources, we always make, and Tessa's going to talk a little bit about personal data, quote-unquote personal data. Our legal holds are always going to tell employees, and it's particularly applicable to high-level employees, that this applies to data and documents that they may have on their personal devices as well. In terms of practical tips, instructions on how to comply are really important. You're often going to be, almost always are going to be sending these to people who are not attorneys. They may run the gamut of being very sophisticated, highly educated employees to rank and file employees who don't have any understanding of how legal situations work. So what they're supposed to do is very important. Instructions on what to do for future documents. Employment cases, when the person is terminated, usually that'll be a pretty strong cutoff point in terms of the company is not often going to be creating relevant non-privileged documents after that point. But of course, if you've ever litigated in a situation where you have a claim from a current employee, every day there may be relevant emails and relevant documents that are being created. There should be a contact person for questions, and there should be an affirmative acknowledgement so that it's clear that we have something documented that not only did the person receive it, but they signed off that they understood it and returned it.
The only thing I want to add about personal data, so when we're talking federal rules and most state court rules, you're obligated to preserve and then produce anything that is in your possession, custody, and control. And the control is what's being debated by in many states and federal courts. What do you have control over? Is it in some cases they say it's whether you have a legal right to control. There are some places that are moving it a little bit they're saying it's the practical ability to control. So what state you're in is going to depend the outcome of that. But what we usually say is you should advise your employees that we are asking you to preserve what's relevant to this particular matter. However, if whether it's stored on company email, company devices, or on your personal devices, and then Tim alluded to this, the higher up the employee is, say you have a CEO, a C-level employee, and they're using their personal phones to text, they're using their personal phones or their personal email accounts to communicate about company business or something that's not relevant, you're going to have a very difficult time claiming that you have no control over that person. Yeah. And there's even some cases out there that talk about former employees that are receiving severance packages, that there's still financial control over that employee, and you could have asked. And what I tell people is that whether or not ultimately you have to turn that over will be determined by the law in that jurisdiction. And you can make arguments you're not going to. However, you're not going to put yourself, the company is not going to be in a very good situation if you don't at least attempt to ask that high-level person, that at least tell them you need to preserve it. Yeah. I mean, they can make an argument down the road, I'm not going to give you this stuff, it's on my personal device, but at least you've asked. You don't want to be in a situation where the judge asks a witness, and I've seen this happen, why didn't you preserve it? Well, my attorney or my company didn't tell me I had to. Yeah. So just make that very clear.
Yeah, and that's absolutely right. I mean, we people are very reticent, especially about their quote-unquote personal devices, to say, well, who are you going to turn this over to? And the answer that I always give people is, well, no one for right now. And we may never give this information to anybody. But we at least need to preserve the possibility. We need to preserve so we have that flexibility going forward. And as we're going to talk a little bit in the sanctions, there's practical implications of this too. To the extent you don't preserve data that is crucial to proving your case, to defending yourself in court, you're not going to get sanctioned for that, but you may have just lost the case because you didn't save the emails that would have won the case for you. So in terms of the what I would call the IT hold, that needs to have a couple of things. It needs to suspend auto purge and deletion of emails and size limitations. I talk to witnesses and custodians of documents all the time, and no one ever knows what their auto delete or size limitations on their email account is, but the IT person will know that and will be able to turn it off for that person. You're going to want to look at, to the extent they tell you they have specific documents, you're going to want to look at collecting that. You're going to want to make sure IT is aware of the people who are covered by the legal hold and is putting in place processes in the event that that person leaves the company, what's going to happen with their data. The same is true of, making sure that IT is aware in the event there needs to be a hardware or a software change to that person's device, that we do that in a way that preserves documents. There's going to be backup tapes that are going to cover what's not preserved as of right now in terms of on the server, and we can at least evaluate, get information from IT to evaluate backup tapes. And instant message logging is one thing, especially that could be important in a current employee situation. And if I know Outlook has it, and Skype for Business has all sorts of IM considerations, and you may find companies that have where just for whatever reason that's how people do a lot of their work is by IMing. So consider to what extent those are available and how to log them going forward. And just a couple more tips. Tessa, go ahead.
Yeah, before we get to the next set of slides, I just want to talk about the important thing here is that you make sure that you do whatever it takes to safeguard those items that are relevant to a lawsuit or relevant to a charge, whether it's pulling personal data, pulling paper documents or getting IT to preserve it. What's the key is that electronic items obviously can get deleted a lot quicker. So it's important now that you actually put a hold on. A lot of people that we work with, a lot of companies now are in Office 365, or they have email servers that allow you to put the hold in place directly on the server. Those are what you should be instituting. You want to keep electronic items which can be deleted very easily from being deleted. So that's what's important. 10 years ago we weren't doing collections as much, but now we are doing collections, meaning we're doing whatever it takes to make sure the data is not deleted. We may not be needing that data, but we need to make sure it's preserved. And as Tim mentioned, what's important with charges is that sometimes they come through and you think, okay, nothing's going to happen here. And it's going to take a while, and you need to make sure you take the steps to store that data for whenever the lawsuit action comes to play.
Just another few other tips. If you're counsel and you're handling a hold internally, that's totally fine, but these are things that you're going to want to be aware of for an IT hold, defrag programs that may result in lost data.
And that first one is really because in cases where metadata is important, whether or not somebody changed a document or somebody took a document, you want to be able to prove things. When companies run things like defragmentation and file compression, it changes the metadata on that document. The other thing that I think is kind of important on this particular side is that a lot of companies rent their computers. Their people are leasing items, and when there's a rotation, you need to be careful that everything on that previous computer is moved over if you haven't actually preserved it. So that's what we're talking about there. But ultimately, the big red letters, reasonable and proportional, is the court's going to look at, did you do what was reasonable and proportional with what the claims are in the case.
Yeah.
And before we go on, Tim, I want to ask, one person asked the question is what is a light hold, meaning L-I-G-H-T hold? I think I used that term. And what I meant by that is the previous question before that is there a problem with doing a hold where it's in the gray area? You're not quite sure if they're actually threatening litigation, but is there a problem with going ahead and doing a hold? And I said there isn't a problem with doing the hold, but you don't want to say it's only the gray area, so I'm only going to do what I term a light hold, meaning I'm not really taking all the steps necessary to make sure everything is preserved. That's what I mean. A light hold is not following through on what your normal procedures would be on a case, and that's not a good idea because a court will evaluate. The court's not going to say, well, you were just in a gray area, you didn't have to institute a hold.
Right.
The court's going to say, oh, you instituted a hold, but you didn't do a very good job, or you only protected things that were important for the defense. So that's what's important.
Yeah, and so to the extent the question is what is a light hold, I think the answer should be is that there is no such thing.
Don't do a light hold.
There is no such thing. Yeah. And Tessa is going to talk a little bit about, following up on the hold as a case progresses.
Yeah. So even though I would say a written legal hold to both IT and to custodians is a requirement and almost mandatory that you really do need to do that, the court is not going to be satisfied with just that. Courts have been really highly critical of companies and outside counsel really that make sure a written hold was done, but then they do nothing to make sure it was followed. So you have to show affirmative actions in confirming that there's compliance. So what I would say usually, you need to interview custodians to make sure that you're locating relevant data, because sometimes they may not understand the hold, or IT may not know where everything is, so make sure that you do that. In a lot of cases, the case will change. The charge may come in with one claim, but by the time that the case is actually filed, it looks different. So look at your hold. Is it time that you do a supplement? Do you need to update it? Cases that a charge has been sitting around for a long time, or a case, you might need to do a reminder hold, reminding people that this stuff is still on hold, especially if everything hasn't been collected. One thing that IT will appreciate is if you ask them to suspend certain things. Maybe you ask them because you didn't know initially how many people would be involved, and they suspended legal email deletion on 100 employees, but now it's a year later and Tim has been involved in the case and you only need 50. It'd be a good idea to tell them they don't need to have the legal hold. So this is a fluid process. It's organic. You got to keep going with it. You got to make sure that everything is being done. You also want to make sure that, like I said, ensuring compliance with it. I did put in there, there are some cases where we do get agreed to orders in the beginning, so that you understand exactly what needs to be held. And then the other thing that we have on here, even though it's really at the conclusion of the case, don't forget to release that hold.
Yeah.
Who else should receive notices? So this kind of goes to what I talked about earlier, possession, custody, and control. Let's go back one, Tim. Yep. So, actually, I think, okay. Agents and independent contractors under the company's control. So we've seen plenty of cases where a company is hiring an agent or independent contractor, and they're involved in litigation. And what you'll find is most companies, most cases, courts will say that you have the ability to control that employee, that independent contractor, So you should be sending them that legal hold. I would caution when we send third-party holds, we're a little bit more careful on what we're going to say. Assume that it'll be discoverable. It may be a more general hold, but it's a good idea to send that hold to them. Another party is a third party. What if there's a third party involved that maybe the plaintiff for sure would never know about? Maybe there's a product that was being used at the company. Maybe they were, let's say it was a car, and that car was involved in something with the employee, and then the company decided to sell that car, and it's going to need to be evidence. You need to make sure that the potential plaintiff or the plaintiff in the case, if there are third parties that have information that you know about, you need to at least either notify the plaintiffs or send that legal hold out. And then finally, there's a question of should you be sending a legal hold to opposing counsel or that future litigant in the charge case? And that's really a strategic question. A lot of times, like we said, plaintiffs have the duty to preserve their own data, and they have a duty before a defendant does in the case. And the question is should you be sending that opposing party a hold? And I would say if there is an item that you think would be important in your defense, and they could make an argument that they didn't realize it would be important in your defense, then I'd say go ahead and send that letter out.
Yeah, it's not, oftentimes in sending a response letter to a preservation letter, I'll put in there, and of course, you've obviously been on notice of your obligation to preserve documents from well before this, so please, confirm that you're doing that. I can tell you in every plaintiff's deposition I take, I have a section about trying to determine when they first decided to bring a case, and then specific follow-up questions about, their text messages, their emails, their Facebook profiles, their other documents, and what steps did you take, if any, to preserve those, just to preserve the possibility that, we're going to have that kind of an argument to flip around on them.
Before we go on, Tim, let's look at a couple of these.
Yeah, there's a couple of questions. There's a question here about there can be problems with depending on a custodian to preserve the documents. When cannot an employer rely on custodians to preserve? Tessa may follow up on this, but generally speaking, I think we would advise against what I would call preserve in place, which is relying on basically any level of a custodian to preserve the documents themselves.
Yeah, I agree. I mean, I don't think it's a good idea to rely on a custodian to preserve, and I don't think an employer can rely on an employee to preserve. I think you need to, those are what we're talking about, you need to collect the documents. Unless you're in a system that you can lock it down, you need to collect. So the question was, can you rely on an employee? No. The only time I would say it's a little different, sometimes we have cases where the general counsel is actually involved, and I've let the general counsel hold things because they have a separate ethical duty. So we've done that. But usually you don't want the employee to do that.
Yeah, if it's the rank and file employee, especially if it's one who's been accused of wrongdoing, and you later discover that something has been lost, yes, I would agree a court's going to look very badly on that. There's a question here about after receiving a demand letter, how long is it necessary to hold information? That's going to be a case-by-case determination unfortunately depending on the statute of limitations that are relevant here. Now that's very conservative advice, but I can tell you we've docketed years in advance. If somebody says they're going to sue you for breach of contract, they may have a 5-year statute of limitations on that. And while I've never seen this litigated where 3 years later, they get around to filing and you've lost documents, I think as a technical matter, unless and until the statute of limitations has run or there's obviously been a final judgment in the case, you're under an obligation to preserve.
Yeah, I agree. Statute of limitations, and I've seen some recent cases where they're questioning why didn't you hold it as far as statute of limitations.
And there's one question real quick here. Does work product in anticipation of litigation apply only to the work product of attorneys? Basically, I would say yes, to the extent counsel is asking non-attorneys, employees of the company, to compile documents, to compile data. I would regard that as, that would be protected as work product.
Yeah, if you're doing something at the direction of counsel.
Yes, but generally speaking, if an HR employee without the direction of legal counsel is doing an investigation, that's never going to be, it's not privileged and it's not work product.
Getting to questions, are we roll through it?
Yeah, we're going to quickly talk about sanctions. As I talked about, Zuba Lake case in terms of the number of documents. Employment cases are somewhat unique in civil litigation in that there's going to be a disparity of documents. Plaintiff may have, some files that he or she printed off versus the company has all the emails, the company has all the personnel files. This should really only serve to highlight the obligation that employers have. So what are the possible sanctions? There can be serious consequences, skipped ahead, if documents are lost. There can be court-imposed sanctions. There can be monetary sanctions. There can be what's called an adverse inference, which is a jury instruction that's going to tell the jury, and really either party, but suppose it's the employer, that's going to tell the jury someday, hey, I've determined that the XYZ company lost this document, and you should infer from that it was favorable to the plaintiff's case. And ultimately, the really terrible sanction, which I can tell you courts, I've dealt with a case in the last year or two where default judgment or dismissal was a sanction that was under discussion. It wasn't ultimately issued, but that's the ultimate. There's practical points as well. Tessa will talk a little bit, I think, about at least under federal rules, the standards are getting a little bit higher to get sanctions, but there are going to be practical implications as well. You can lose documents that's important to prove your case, and it may look bad to the jury even if the judge doesn't specifically tell them to what they're supposed to find. So if you've got a key witness up there who's having to talk about, oh, well, I deleted that email even after counsel told me not to, yeah, the jury's going to look badly on that even if the judge doesn't tell them to.
So the one thing I want to say about sanctions is at least in federal court, the latest amendments to the rule has basically standardized sanctions related to electronic discovery spoliation issues. So that is good for companies that operate in more than one jurisdiction. Unfortunately, states are not quick to be following through with that. The one thing that is really important in that rule is that you have to, in order for someone to get sanctions against a company, now they have to show that there was a duty to preserve. The other thing that's really important now is that you have to show that you failed to take reasonable steps. So what we always counsel companies are, it is very important that you set up a process to handle legal holds and that you be able to show that, look, we have this legal hold process in place. We have steps that we take. We took reasonable steps. And I think right now, if you can show that you took reasonable steps, it's very difficult under the new rules to show sanctions, especially the high-level sanctions. So high-level sanctions require bad faith. But if you say, look, I send out a legal hold, I talked to IT, I took steps to do this, but yeah, maybe one custodian left and somehow he didn't get on the list, but if you've taken reasonable steps, I think it's important to, they'll have a difficult time to show that. But the other reason that you want to consider this is that keep in mind, it's not just whether you get issued with sanctions. The cost of defending this can be kind of expensive. So that's why we're saying it's important to take steps to make sure that the hold is done properly.
All right, we're running pretty tight on time here, but Tessa's going to talk as a final topic about investigation.
Okay, Tim, you want to just get to the next? So this, I'm going to talk a little bit about different devices and how to handle them, especially in employment litigation, because I get these questions a lot. So let's talk about a personal computer. Your employee, maybe an employee has left and has gone to your competitor, and I get a call like, we have the computer that he was using, we think he took stuff, how can we show it? The first question I usually always get is, should we do a forensic image? If you're talking about just, hey, there's a charge and I want to hold somebody's computer, I advise people, if you don't want to spend the cost on forensic image, just pull the hard drive out, have somebody in IT help you do that, and preserve it later. But when we're talking about doing an investigation, somebody getting into that computer and looking at data, I always advise people do a forensic image, because otherwise, if you work on the original computer, you're going to leave a digital fingerprint. So it's always a good idea to do a forensic image first. Then the question I always get is, what can you tell? Can you tell if the ex-employee took a document and put it on a USB port? What can you tell? Well, there's also, usually you need to hire a forensic examiner to do this, but there's all sorts of reports that you can have them generate, and there's a lot of information inside a computer, but sometimes it's not quite what you think. You can figure out if a document has been created on that computer. You can figure out if a document has been accessed, even on your network, and there's even reports that will show if a particular document was printed from that computer. There are recycle bins in computers that are not that easy to dump, that are part of a register that's harder to get to. And a lot of times we'll find interesting documents in that recycle bin. The biggest question I always get is, can you tell if somebody did something and took it out on a USB, a thumb drive? So there's a device report which will tell you every time a device was plugged into that computer, and it will give you the registration number on that device. So some companies, what they do is they've limited employees' ability to use USB devices except for what they register. And so you can register that to employee. And so even though you can read documents from a thumb drive, but you can't copy documents to a thumb drive unless it's specifically registered to the company. So that's just a little extra advice that you might be able to do that. But that report is basically going to show you this thumb drive was plugged in on this date. And hey, that might be relevant because the employee was on suspension and then terminated, and it looks like 2 days before he left, he was putting thumb drives in and a lot of activity. But then the next question is always, can you tell me what he copied or he or she copied onto the thumb drive? Unfortunately, the answer is no. There are no reports that will show that. What you will see is if an employee copies a document onto a thumb drive and then they open that document, it will create what's called a link file. And using a link report, I can tell that, hey, somebody inserted a thumb drive, and I can also tell you when a particular document was opened on that thumb drive. And if that document is something that the employee shouldn't have had in his possession, then it will help you. But unfortunately, a lot of times what happens is they have employee documents that should be there, but the link file will show you what's been opened. You can also find out from a forensic investigation whether or not somebody's done internet searches, whether or not they've accessed a cloud service, which is usually important in the investigations we do a lot, because anymore people don't usually take things out by thumb drive. The number one way people take information from a company is they access a cloud service, and they move data that way. They're not using their employee email to send it to their Gmail account anymore. People have gotten smarter. Instead, they're going to access a cloud service. They may have a OneDrive service, or they may have a different service that allows them to upload things, and that's what they're doing. The other little note on there is just a piece of advice about tracking computers. In a lot of these investigations, and I've dealt with this one recently, where it was a smaller company, they hired an IT company to help them with employee laptops. But what they failed to do is they didn't put any tracking information on the laptop. So when the employee left in not a very good situation and took that computer with them, they couldn't track it. And the employee said, hey, I lost it. And so there was no information. There is software out there that helps you track laptops. There's also software out there, and we're going to talk about it in the next slide, that helps you with phones, wiping phones. So let's talk about smartphones and tablets really quickly. Okay. With company-owned devices, a lot of times the situation we get in is an employee may be involved in some sort of situation, there's threatened lawsuit, and they want to cooperate, and they have their company phone. So you have their company phone and their password. What can you look at on that company phone? Email's easy. It's company email. In the United States, the email is employed by the employee. But usually you don't want to look at it on you're not collecting it off the phone. You're going to collect it off the server. The only situation that would be different is if there's still at least one employee out there. I think in this firm there's one that still uses a BlackBerry. With the BlackBerry, you can actually save an email onto the hard drive and then delete it from the server, and you wouldn't know it. So that's someplace. But when you have that employee, even though it's a company-owned device, a lot of employees, including myself, I'm receiving personal email on that. As you're looking at that employee's phone, even if it's owned by the company, you have to be really careful on the issue of can you look at that personal email. There are a few cases that say if that device is owned by the company and the company has made a clear statement in their personnel policies that say that the device is only supposed to be used for personal, then you may be able to look at it. But you really have to know the rules, the law in your jurisdiction about that. And you need to be very careful. If that phone is still accessing Wi-Fi and new information is being downloaded from the Gmail account or the Hotmail account, whatever account they're using, and that information has never been looked at by the employee, there are arguments that say that that information is still located at the service provider, and there's a law, the Stored Communications Act, which unfortunately is a very old law, and Congress is trying to change it, but it is deadlocked right now. And with that law currently in place, you cannot look at information that is stored at a provider. So my Gmail, because if an employer, if I agree to turn that over to my supervisor and they're looking through it, that Gmail that hasn't been opened or is just downloading as they're looking at it, you're not allowed to look at it. You have a stored communication violation, and that's an issue. Text and social media. Text, the only place you're really going to be able to get it is from the employee's phone. There is software that allows you to be able to do that. Unfortunately, most of the time the software, it's better if you collect all text and then you have to discuss with the employee what text should be resolved, because you can't go, even with a phone that's owned by an employer, you can't go to your service provider and get those texts. They're not kept that long. The last time I checked, there was only one service provider that actually kept text, and it was so short you'd never get it. So the only place you're going to be able to find it, if it's relevant to information to your lawsuit, is text on the phone. Social media is kind of the same thing. I mean, if you know of social media that is out there that is concerning, you obviously can do quick screenshots and collect it. But social media also downloads to phones, especially iPhones. If you look at your own iPhone and you're not you're not on Wi-Fi, but you'll still notice that all your Facebook things are there. It's because if you use an application to look at social media, it will download it. If you look at social media on your laptop and you're not using an application, it's not downloading. So be careful with social media. Just because the employee, you have that phone, same issue with the Stored Communications Act. If it's still residing at Facebook and it hasn't been looked at yet by the employee, you have issues. There are also some states that have privacy laws regarding an employee's right to look at social media and an employee's right to ask for social media account information. There are a few states that say even private employees you cannot ask for that information, and there are definitely states that say public employees you cannot ask for that information. The other things that are usually on phones that we sometimes need to be getting is pictures, and then there's also other apps, and that information, you'll be surprised, is actually stored on a phone. So if an employee is involved in litigation and they have data that's important to a case, you may have to forensically remove that data. Personal devices, the only thing I was going to really say is obviously it's a personal device, but you have a BYOD policy. Hopefully in there you say that if you're using your phone and we're permitting you to use your personal phone and receive work email, then, and it becomes relevant, the data on it for litigation, then you will voluntarily cooperate. The one thing I wanted to point out with personal devices, same thing with computers. If you're allowing an employee to use a personal device to receive company information, what's going to happen when that employee leaves? And maybe it's not because of a good situation, and they leave and they have all these emails that have important documents. If you do not use a mobile device management software, you will not be able to wipe that information. So this MDM is what it's called. If your company is allowing employees to receive personal work email on their personal devices, it's always a better policy to use an MDM software. It will allow you to compartmentalize, meaning if an employee walks out the door, you can wipe their work email by doing that. If you do not do that, and if you just give information, and I just had this happen, the company just gave them instructions on how to receive work email, but didn't bother with the MDM. Two problems happened. Well, the biggest problem happened is the employee left, and even though we were able to, they shut off access to the work email, they were not able to wipe that email. All of a sudden, all this important and proprietary information walked out the door, and they couldn't do anything about it. Move on. I know we're at the end here, so let's. Company email, the only thing that I need to remind you, if there's a legal hold, you need to make sure that you have preserved the documents. One thing that I talked about, stopping access, and this has to do with what I just said about personal devices. So in that situation, it was a smaller company. Person had a personal phone. They were allowed to access company email. They were given instructions on how to do it. When they walked out the door, what they did is they deactivated the company, they changed the password. Once they changed the password, they had no ability to wipe that phone. When they were using a service to push, they could wipe it, but the problem is they didn't use the correct way to push information. They didn't use an MDM, and so you can only wipe the whole thing, which kind of gets into other problems. And then when they deactivated, which is another way to do it, all of a sudden the link was lost and we didn't know where the phone was anymore. So just be very careful and make sure your IT department or whoever you hire to deal with delivering company information onto devices knows the best way to do it. And if you're monitoring live accounts, one thing I did want to say, make sure that you log in with an admin login so that you're not changing information. And the final thing I think
we've talked a lot about some of the social media information already.
Yeah. The only kind of hint I would give on capturing social media, obviously when you see something an employee's posted and you want to capture that, the quickest way to do it is do a screenshot. Because by the time you call a company to help you do the collection, a lot of times if it's bad information, that's going to be gone. So when you do that screenshot, sometimes what I would suggest is have somebody videotape it and have them look at a clock so that that you're pointing to the computer clock and you can verify all of that information. And then also be careful when you are snooping. If it's public information, it's one thing to be able to download it. Private information, you can't ask, especially if you are an attorney acting with a license and acting as in the HR department, there are all sorts of ethical rules and bar association rules apply. You cannot ask a friend of the employee to let you become the friend so they can see stuff. So be careful how you snoop. Privacy laws and ethical laws apply to attorneys. But if you're in the HR role with a license, that could impact you as well.
All right. Well, we've got one or two questions that we'll follow up with offline, and thank you all for joining us. Tessa has a little housekeeping end.
Okay. Thank you for joining us for our program today. We hope that the information provided was helpful for you and your organization. If you have not already done so, please click on the survey icon at the bottom of the screen and complete our short survey. Your feedback assists us in providing quality future programs. And then as a reminder of what Ashley said, this program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. And it's been approved for HR Certification Institute and Society for Human Resource Management recertification credit as well. And a recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with the certification of attendance. So this concludes our webinar, and as Tim mentioned, there's a couple of questions that we did not get to. We will answer those, I think, by email, is what we said.
Thanks, everyone.